The Texas justice system is messy, so let's break it down. You're listening to So You Got Arrested, the podcast that tells you what really happens after an arrest. Hosted by BRCK Criminal Defense attorneys, we talk to the people who've lived it, worked in it, and been shaped by it. Whether you're facing charges or just want to understand your rights, your options, and the smart moves that could change everything, we've got your back.
So, Scott, my son is over at college, and he moved out of the dorms this year.
All right.
And so we got him an apartment that he shares with some roommates. And it's kind of a weird situation because it's an apartment that has like 5 bedrooms, and he has these roommates, and they share this apartment. They each have their own bedroom. Some of the roommates are his friends, but a couple of them he never met prior to this year.
Got it.
So I was thinking about this the other day. He just moved into this apartment about a month ago. They share, kind of the living room and the kitchen. They share the refrigerator. They have he has his food in there. And I was thinking about, if one of his roommates was to go into the refrigerator and eat some of his food, and maybe my son gets mad and they get into a fight, and it turns into a physical altercation, what kind of case could that be?
So it should first of all, if it's mutual combat, there should be no charges. A lot of times police officers will come out to a scene where 2 people get into it. You can't really determine the aggressor. And I've always argued that just because somebody won the fight doesn't make it a criminal case.
Right.
But it really does in the eyes of law enforcement. So if somebody ends up beating the heck out of if your son wins the fight,
right, the other guy
he's liable to be arrested for just a regular misdemeanor assault.
Okay.
However, what we've been seeing is because they're roommates legally and meets the definition of assault, family violence, dating, household.
Right.
Okay. Which is still the same thing, still a misdemeanor. But it has other consequences.
Mm-hmm.
So go ahead.
And I was going to say, and part of the reason it's, a family violence case is because of the way that the Texas Family Code defines family violence. Family violence is an act by a member of a family or a household against another member of the family or a household. And households defined as just persons living together in the same dwelling.
Right.
So this would qualify as family violence.
It qualifies as family violence for sure. Whether it should really be done as family violence, different prosecutors would weigh in differently on that. When I was a prosecutor, I wouldn't have taken it as family violence. I don't want to get too much in the weeds on this issue, but so generally, when you have just say it's a really legit family violence case where a guy assaults his living girlfriend, okay, they don't have to put in the charging it for the misdemeanor information that family member or a dating relationship. They could just say assaulted this woman by striking her with his hand. Mm-hmm. And then the court can make the family violence finding or member of household or dating relationship, that family violence finding after the conviction. Okay.
But the charging it as a family violence case, when people get charged with the family violence case from the outset, there's additional consequences than you might find in a regular assault case, right?
Right. You were all kinds of different things happen.
So what, for example?
So first off, if you're convicted, not deferred adjudication, but if you're convicted and there's a family violence or household, so every time I say from here on in family violence, that includes a household member, like you said.
The scenario with my son.
Exactly right. Okay. So if you're convicted and there's a family violence finding, under federal law, you can never own guns or ammunition the rest of your life.
Okay. So that's lifetime.
Yeah.
Wow.
Yeah, that's forever. Okay. The other thing is, even if you get deferred adjudication, so it's not a conviction, so it doesn't invoke the federal statute, and now you get into another fight with another roommate, now it can become what we call an assault second, where you have one adjudication or conviction. Doesn't have to be a conviction for this, an adjudication.
Like you got probation.
You got deferred adjudication, probation.
Right.
Okay. Not a conviction.
Right.
Okay. But now you get in, and so you can prove that prior was against a family member or a dating person or a household member. Mm-hmm. Now you have another assault against the same type of thing. Now it becomes a felony, punishable by 2 to 10 years
in prison.
Yeah.
Yeah. Yeah.
Now I'm not saying you wouldn't get probation on that felony,
right?
But it's probation that if you mess up, you're looking at 2 to 10. Right.
It's a much more serious offense.
Completely different. I mean, nobody wants to have a felony conviction.
Well, not only that, but when you get charged with these family violence or household violence cases, there might be additional conditions just on your bond while you're awaiting, your trial, while you're going to court. There's additional conditions that they can put on you.
Right. The new statute we talked about two episodes ago, where you have to be held for an extra 4 hours if there's if it's a family violence household assault. You're very much likely to have a GPS monitor on your ankle if you have that type of charge. And so I would encourage law enforcement to not charge because that's not the intent of the family violence statute, is two roommates get into a fight.
Right.
That was never the intent. Okay. Right. I don't know if I mentioned this on a prior episode, but when I was prosecuting in Medina County, we had the sheriff's department trying to file family violence assault cases on two guys went on assault at the jail.
Okay.
Okay, so two guys were in jail, so they're sharing a dwelling, and they filed as a family violence assault because they're same household, the jail. I'm like, we're not doing it that way. No, right. It's just a regular assault. There's nothing wrong with just calling it a regular assault.
Right. And I know that, when you were a prosecutor at the Bexar County DA's office, you handled a lot of family violence cases. And I can always imagine that those are difficult cases to prosecute, but because oftentimes, correct me if I'm wrong, the complaining witness, the person who's on the receiving end may not want the case to proceed.
Right. And so when I first started doing this in like 1996, okay, we had just started going forward on cases without the victim's permission.
Okay. So that's a scenario where maybe in the scenario you gave, the live-in girlfriend says, hey, I don't want this prosecuted. I want it dropped. I don't want you to carry it forward. And
we didn't care. We went forward anyway.
Okay.
So there's confusion on this issue because a lot of people will say, oh, well, because it's a family violence case, you can't dismiss it. We can dismiss it if the case sucks. Mm-hmm. Okay. But if the case is good, if we got a 911 call saying he's beating me up and there's pictures of bruises, we're taking what the victim wants to do out of the equation about how we pursue it. Mm-hmm. And there's a big reason for that.
And what is that?
Because back in the old days, you used to have these guys beat up their wives every time they got drunk, and they would keep coming down and swearing out at things, saying, I want to pursue charges, and the charges would be dismissed. And the officers got sick of coming out to that house every month.
Right.
And back in the 90s, I knew as a misdemeanor prosecutor in Bexar County that the rate of family violence assaults always went up when the Cowboys lost.
Oh, wow.
Yeah.
I didn't know that.
No, when the Cowboys lost, we had a bunch of family violence assaults. Now it's so commonplace that nobody cares anymore. So you can't sit there because you don't know what's going on in the household. So is he intimidating her to get her and saying, I'm going to beat you even worse if you don't try to get these charges dropped? Right. So we have to take that whole thing out of the equation and say, you violated the law. The police came out to your house and made an arrest. Whether the victim wants to pursue the charges or not, We'll listen to it, but it's not really relevant to what we're going to do with the case.
And that does cause confusion because from time to time, we get the complaining witness or the victim on the case saying, hey, I told the prosecutors I want this case dropped. Why haven't they dismissed it yet? Right.
So that as a defense attorney, our clients get mad, like, well, why haven't you got this case dismissed yet? My girlfriend doesn't want to pursue. I'm like, because they have good evidence. I mean, sometimes those 911 calls are very compelling. Mm-hmm. And nowadays, most jurisdictions, when the officer comes out, there's body cam. Mm-hmm. And so everything she said to the officer about what he did is captured on body cam. Mm-hmm. And so now she may come in and say, I lied to the police officer, but we don't believe it's a lie. We believe that what she said when it happened is more accurate. That's why there's an exception to it in the evidence code, why you can call it an excited utterance.
Right. So you have a situation where the officer arrives, he's running his body cam, and you have, the girlfriend, crying with a bloody lip, and the guy outside without a shirt pacing back and forth, or whatever the case may be.
Right. And sometimes the body cam's catching the guy saying, you better shut the hell up, right? And that's a damn good case for the prosecution. I don't even need her to come.
Right.
I have the pictures. The officer can identify the parties. We have video of the body cam. We have a 911 call. I just need to put that officer on. I can prove the whole case through the officer. So so as prosecutors, we are required to listen to the victim when they call, but we're not required to do what they want.
It's not their case.
It's not their case.
It's the state's case.
Yeah.
Yeah. And so, what I found interesting is the law on family violence has been evolving.
So much.
I've been practicing 20 years, and I remember back before we had laws like continuous family violence. And so could you explain what that is?
So back, going back to the 90s when I first started doing this, you could assault your girlfriend or your wife time and time again, and every time it would just be a new misdemeanor. Mm-hmm. So you've already known that you're only getting a misdemeanor for it. It's not stopping. Okay. And so I think it was in 1999 when they first passed a law saying, okay, and this is similar to what other states had done before Texas got around to it, is so if you assault a family member or somebody you're dating or member of a household and you plead to it, now if you do it again, it becomes a felony, the assault second we mentioned earlier in the show.
Right.
Okay. And so when that happens, now you're looking at a felony rather than a misdemeanor. And so that happened. So actually, originally, when they passed the law, they made it assault third.
Okay.
So back in the late 90s, they made it like the DWI statute. You had to have 2 family violence adjudications, and the third one became a felony. Mm-hmm. That only lasted 2 years. The next legislative session, they said, well, this is silly giving them 2 assaults before. And then, so the very next legislative session, they said, no, once you have 1 prior, the second one becomes a 3rd-degree felony, 2 to 10. Then in the 2000s, they created the continuous family violence statute you mentioned, because what we were having a problem is you still, in order to make an assault second, there had to be a plea.
Right. The case had to be, that first assault had to be finalized with either a conviction or a plea.
Correct. And so what you were having is people assaulting their girlfriend or wife, and then because they hadn't got the charges dismissed, assaulting them again, and we still couldn't do it as a felony yet. Mm-hmm. So they created the statute called continuous family violence, meaning if you have 2 assaults within a 12-month period, again, and it doesn't have to be against the same person.
Right.
Okay. You could assault your mother in June and assault your girlfriend in July, and both of these cases are still pending. But instead of having 2 misdemeanors now, they're going to combine these 2 incidences and create it as a continuous family violence assault. Once again, 3rd-degree felony, punishable by 2 to 10, but they have to prove both separate incidences beyond a reasonable doubt. Mm-hmm. Okay. Generally, as a prosecutor, usually on those continuous cases, we had 1 really good offense and 1 that was kind of shaky.
Right.
Okay. But you have to prove up both of them.
Both of them during the trial for the conviction.
Correct.
Yeah.
Yeah.
And so, in those circumstances, when you were prosecuting these cases, I'm not asking for a percentage, but just generally speaking, how often were you dealing with cases where the victim didn't want to pursue charges?
Well, it felt like around half the time. Okay. And I had victims who would come in. So this is important for everybody to know. If you're feeling like that if things, we hear this all the time, it got blown out of proportion, right? How many times have you heard that? So I do want to listen to what the victim is telling me. And I've had victims come in and they lie to me right off the bat.
Mm-hmm. What do you mean? How do you know they're lying?
Because I'll say, well, you're saying that the police shouldn't have done this, but you called the police. And they're like, oh no, it was a neighbor called the police. Now I haven't listened to the 911 call yet. And I'm like, are you sure? Because I'm going to go listen to it. No, I never called the police. I go listen to the 911 call. They called the police. Right. You can hear their voice, right?
Crying on the phone.
Right.
Yeah.
And so now they're not credible to me anymore. Right. Okay. And so now they have much less effect. Like what they want to see happen has much less influence on me.
Right.
Okay. So don't lie to people when you're trying to be honest about it, and you have a better chance. I've had victims sit down with me. I actually had a victim once say, I am not afraid of my boyfriend. I can take my boyfriend. I was a female wrestler. I'll if you want to wrestle me right now. And she convinced me to dismiss the case. She didn't put me in an arm bar or anything, but she did convince me that, because what we worry about, we don't want somebody to get killed by the person they're in love with.
Right.
Okay. Right. And we never know which are the cases that are like really dangerous and which are the cases that it's got blown out of proportion. We have no magic way of knowing.
You don't know what the dynamic is in that household.
All we can do is look at the facts of this particular case and see how bad it is. Mm-hmm. When we hear threats of like, I'm going to kill myself, or if I can't have you, nobody will, makes us nervous.
Absolutely. I'm sure.
And so when you hear that kind of stuff going on, you'll be like, I'm not dismissing this case.
Yeah.
If I lose it in trial because she wants to get up and say it never happened, but in all honesty, I never lost a case where the victim testified for the defense and said it never happened.
Wow.
I've lost plenty where they got up and said, I want him to go to jail forever.
Yeah.
But when they got up and said it didn't happen, the jurors never bought that stuff.
Yeah.
They know what's going on.
So we have plenty more to talk about when we come back after the break.
That went fast.
The attorneys at BRCK Criminal Defense have helped over 5,000 clients move on with their lives. When an arrest or accusation turns your life upside down, we have the knowledge, experience, and integrity to get your life back on track. Traditional legal ethics, modern legal tactics, the best defense possible to get you through the criminal justice system. Search BRCK Criminal Defense to see our reviews and find out why so many of our clients have trusted us to fight for them. BRCK Criminal Defense, helping our clients move on with their lives.
And so a lot of times on these family violence cases, you have additional proceedings that happen, like, for example, the Family Violence Protective Order.
Yeah.
And could you explain what that is?
Sure. So now I want to be very clear. There's an emergency protective order that happens when you're booked that is different from going to court and getting a 2-year protective order. Mm-hmm. That's a civil suit that's filed. The DA's office will file those 2-year protective orders for you, but you got to handle those in civil court. But when you're booked for a family violence offense, frequently the officer will request an emergency protective order, which can last from 30 to now 120 days.
120 days.
And so there's no real easy way to ever take that off. So you're going to have to live with the fact that you and your significant other aren't going to be able to have contact until that emergency protective order expires. And
so the protective order is something that would keep the person accused of the offense from possibly being able to go back to that household.
Right. And so the interesting thing is, so we have people who are arrested for family violence assault and haven't made bond yet. Mm-hmm. And they're calling and saying, you better get down there and get those charges dropped. Now that's a new charge because they violated the emergency protective order. It's a new Class A misdemeanor. It's punishable by the same way that the family violence assault is. And guess what? Absolutely, there's no way not to prove that.
Right, because now they have a recorded call.
I have a recorded conversation of you talking to her. I talked before about not needing the victim to pursue on some of these cases. You really don't need the victim to prove that one up. I'm just going to bring the jail call person in, show that they violate, and bring in the emergency protective order that he signed when he was magistrated.
Right.
And it's proved.
Yeah. And I imagine those protective orders can be difficult to deal with because, you take a scenario where maybe you have a husband and wife with a child and the wife or, the victim of the case relies on this other person in the household for help with childcare, picking up the kids after school, whatever the case may be. Those dynamics come into play and they can be very complicated to deal with.
We've had that at BRCK where the victim was not able to take care, coordinate, pick up the kids every day and needed to talk to her husband about how they were going to do this. And we weren't able to fix the emergency. Once the emergency protective order was done, then we were able to change. There was a condition of bond also saying no contact at all. Separate issue. I think we probably need to touch on that in a little bit. So we were able to get that changed to no harmful, injurious contact. But the emergency protective order back then, I think this particular case I'm talking about was only a 60-day one. Okay. They just had to live with it for 60 days.
Right.
There was nothing we could do.
Right.
It's more complicated. There is actually something we can do, but it's almost never successful, and it's very difficult. Right. You have to go back to the magistrate's court and file something, and the magistrate's not wanting to change it.
Absolutely. Because, if something does happen, then, it's the magistrate who's rescinded that order.
Correct.
Yeah.
Right. And nobody wants to have put themselves out there like that.
And even, we talk about these consequences that come about. You mentioned this, you could have a bond condition that's in addition to that family violence protective order. Right. That says, hey, you're not allowed to have contact with the victim, which if it's your wife or your spouse.
Yeah, you pretty much always have the bond condition of either no contact at all with the person alleged to be the victim in the crime or no harmful or injurious contact. It's pretty much always a condition. Mm-hmm. Is that true in the 81st also?
It is true. But the complicating thing about family violence cases is, so it's one thing, Scott, like if you and I are at a bar and you're rooting for the Eagles and I'm rooting for the Cowboys and we end up in a fight, just because you don't root for a good team. And, but it's we don't live in the same place. Right. But if it's household violence, family violence, we share a household. And now there's this bond condition saying, hey, you can't go back home.
Right. And the problem there, obviously, the family violence laws are set to protect people who are being victimized in an abusive relationship. Well, guess what? Sometimes the person who owns the house is the abuser.
Right.
And so now we have a victim with a child who has to move out of his house because, like, if it's community property, they stay and he has to get out. Okay. But that's not always the case. So now that we have a gal who's has no family here, right? And so we have a good battered women's shelter, but a lot of women don't want to go to that.
Of course not.
But we do have a very good one here. And so we have things in the community to take care of people who have to get out because of these kind of situations. And we do have a lot of support systems. Matter of fact, this Saturday, I'm going to be running in it's Domestic Violence Awareness Month, October.
Oh, okay.
This Saturday at Lady Lake is the Purple Run for domestic violence. So there's a 5K out at Our Lady of the Lake to support, raise money for domestic violence awareness.
And one of the things that about these cases is they're complicated. They deal with very, personal human issues, relationships between people. And in some of these some of these larger jurisdictions like Bexar County, we have specialized courts to deal with these and specialized divisions. Can you kind of touch on that? Right.
So here in Bexar County, if you have a family violence case, and this includes these roommate cases, you're going to go either into County Court 7 or County Court 13. And those courts handle nothing but domestic violence cases. And we have so many that each of those courts have an impact court to help them out with the overflow. So there's a County Court 7 impact and a County Court 13 impact that is staffed by visiting judges every week.
And I know even with these specialty courts, there are so many cases that there's still a backlog of domestic violence cases here in San Antonio. I think, the Office of Court Administration, who does these studies on caseloads, determined that Bexar County needed another 3 misdemeanor judges just to handle the deluge of these family violence cases.
But part of the backlog is because we have too many of these family violence cases that aren't really family violence cases.
So that would be the scenario we discussed, like where my son and his roommate.
Well, and not just that, because remember, it's family member too. We got a lot of family violence cases in Bexar County where it's graduation or kindergarten graduation party, and 2 brothers get into a fight.
Right.
Okay, that was not the intent of it. Clearly is part of the definition because they're family, they're brothers. But that wasn't what we got into the business for. We were trying to stop people in terribly abusive relationships from being abused.
Right.
2 brothers getting into a fight at a graduation party is not. And of course, the brother wants to drop charges. And in those cases, we should just hurry up and drop them.
Right.
Because that's contributing to the backlog.
Right. Okay? But instead, they get classified as family violence, and now you have these specialty courts, and there's a division of the Bexar County.
Like a 6-month backlog for them to look at these cases, where I would argue that go through and find all these cases that are just sister or brother and brother that aren't really what it is, and hurry up and get rid of those.
Right.
Okay.
Right.
You have an obligation as a prosecutor to at least reach out to the victim. But I'm telling you, most of those cases, the family's like, we wish we hadn't called police.
Right. Absolutely.
Okay.
Yeah.
But because that is taking away from the reason why we were there, is to help people in abusive relationships.
And by, moving forward on some of these cases and putting them in that family violence pipeline, you're clogging the pipeline, and you're kind of delaying justice for some of people who are, in abusive relationships.
Right. And but the officers really don't have discretion. They're told if there's been an assault in his family, they have to make an arrest. Okay. So it's not from the law enforcement end that's the problem. Is that there has to be a way for the prosecutors to identify these type of cases and quickly dismiss them, so that it doesn't clog up the cases they really need to put their focus on.
Well, that raises an interesting question because, I have always heard, and I'd like you to address this, that, well, if the cops get called and they make the scene, somebody's getting arrested. Somebody's being taken away that night. How true is that?
That is SAPD policy. If there's evidence of violence, they have to make an arrest.
Okay.
Okay. So that is true. Now, that doesn't mean they have to make an arrest if they come out there and there's no evidence of assault. If somebody, they still have some discretion. If somebody says he hit me and they can't, and they look and they don't see any evidence of injury. But a lot of times, even then, they're in abundance of caution, they're going to make the arrest. And it's based on the say-so of somebody who says they got assaulted.
So let me ask you this. I mean, is it if you take the scenario where it's the two brothers getting into the fight at the graduation party, and, so it would be SAPD policy in that scenario to arrest and charge family violence, assault family violence.
Yes.
Once it hits the Bexar County DA's office, I'm assuming the prosecutor could change the charge and say, hey, this is just regular assault.
Yeah, but no, they're not gonna. They're either going to file it as a family assault or dismiss it.
Why is that?
Because that's clearly, it's not like the household thing that you brought up earlier in the show.
Okay.
That's clearly within the definition. I mean, so brothers is because we still have a lot of family violence assaults where kids on drugs are assaulting their mom or dad.
Yeah.
So we're not really dismissing those if they're really truly family.
Yeah.
We can just charge the assaults as regular assaults when they're roommates and stuff, which really isn't the true reason we're there. But we're still going to go forward on the family members stuff.
So these are very complicated cases.
Yeah, no, none of them are simple, and so that's why in the backlog, because if I'm an intake prosecutor doing DWIs, is I look at the BAC probable cause for the arrest. I'm good. I fill out the information. Okay. Here for a family violence case, you're required to kind of reach out to the victim, and of course they don't call you back because they're told if they don't call you back, they'll drop it, which is not true.
Right.
Generally, if you don't call back, they're going to file it.
Right.
Okay. And so it takes more at the intake level to go through it. Okay. But my argument's always been, but on some of those cases where it's brother on brother or room, there was a time where two guys can get into a fight and law enforcement wasn't involved.
Right. You just settle it.
Right. We took care of it. And it was so like how we started this show where two people who live in the same apartment, do we really need to be prosecuted? Now the concern is somebody going to get shot next time because they're mad?
Is it going to escalate?
Yeah. Is it going to escalate? But if everybody's saying it's not a big deal, my one roommate called the police and it's not a big deal when it dropped, that should be an easy decision for the DA's office to just drop that.
Well, and one of the things that I always found interesting about family violence cases that makes these types of cases unique is it's really one of the only types of cases where the victim of the case may have an interest in the outcome of it because of their spouse's job.
Exactly.
Or
right.
their means of making a living. So you may have a victim saying, well, wait a minute, if he gets convicted of this or he gets put on probation, he loses his job and we can't pay our mortgage. We can't, do these things. So they're unique in that way. And I always thought that was kind of an interesting facet of them.
And that's something I took really seriously as a prosecutor. I didn't want them to lose their jobs. So that may be a case where if everything's going okay, I'll dismiss it in a couple months, just to make sure. Obviously, if there's not really, I'm not concerned that it's like a sleeping with the enemy situation.
Right.
Most people don't know what that reference is anymore. Yeah. So because if they lose their job,
you're adding more stress to the household,
and there's going to be more problems.
Right.
Okay. And so if somebody comes to me and says, I don't want to pursue these charges, and the police were jerks. I never wanted to pursue the case of the difference from the get-go, and I clearly see that's not true. Then yeah, I'm not going to be sympathetic to that. But if somebody's like, look, what he did was wrong. I understand what he did is wrong, but we can't live if he loses his job. And then I got to confirm, will he really lose his job, or can I do some kind of deferred where he can keep his job? Or if there's a companion 911 call, interference with 911. We don't have time to get to that.
Right.
But can I plead him to that?
Go on another charge.
And he still takes the batter's intervention class. We get the intervention.
You get the end result that you needed
without him losing his job.
Absolutely.
Okay.
Absolutely.
Now, I'm not trying to say I'm sympathetic to the guy who committed the assault. I'm saying I'm sympathetic to the person who's victimized, who's going to get victimized worse by losing their home.
Right. Absolutely. This is a very large topic, and our 30 minutes just flew by fast. And I feel like we barely even touched on this subject.
We really could probably talk 3 different shows about this.
Absolutely. And we may have to do that in a future episode, but we're going to end it here. So we want to thank you for listening to us. This is So You Got Arrested from BRCK Criminal Defense with Steve Barrera and Scott Simpson.
Thanks for listening to So You Got Arrested. If you found this podcast helpful, share it with someone who needs to hear it. For more legal insights and real talk from the front lines of the Texas justice system, follow us and subscribe. And remember, BRCK Criminal Defense has your back. For more information, visit us at brckdefense.com.